Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today, what I'm going to talk about is payment for the college expenses of your children if you're going through a divorce or if you have gone through a divorce. So let's get right into it. I'm going to share my screen and show you the relevant statute, which is 46B-56C. And it says that for the purposes of this section, educational support order is an order entered by a court requiring a parent to provide support for a child or children to attend for up to a total of 4 full academic years in an institution of higher education or a private occupational school for the purposes of attaining a bachelor's or other undergraduate degree or other appropriate vocational instruction. An educational support order may be entered with respect to any child who has not attained 23 years of age and shall terminate not later than the date on which the child attains 23 years of age. So basically, the court will enter orders with regard to undergraduate tuition or vocational school for any child under 23. Now, on the motion or petition of a parent, the court may enter an educational support order at the time of entry of a decree of dissolution, legal separation, or annulment, and no educational support order may be entered thereafter unless the decree explicitly provides that a motion or petition for an educational support order may be filed by either parent at a subsequent date. And then later it goes on to say that it doesn't just have to be a divorce or legal separation case. It also, in custody cases where parties were never married, educational support orders can enter on a later date. The court may not enter an educational support order pursuant to this section unless the court finds, as a matter of fact, that is more likely than not that the parents would have provided support to the child for higher education or private occupational school if the family were to remain intact. So it's pretty standard in a divorce agreement, which we will talk about later, for the agreement to say that it is more likely than not that the parties would have contributed to the post-secondary educational support of their children if they had remained intact. Because the court does have to make that initial finding before ordering a contribution to college. So the statute goes on to say that after making such finding, the court, in determining whether to enter an educational support order, shall consider all relevant circumstances, including, so the court in entering the order will consider the parent's income, assets, and other obligations, including obligations to other dependents. So they'll look at the financial circumstances of the parents in determining whether or not it makes sense to have them contribute to college, whether or not they can afford it, basically. They're also going to look at the child's needs for support to attain an institution of higher education or private occupational school, considering the child's assets and the child's ability to earn income. So if for some reason a child has, high income or high assets, the court's unlikely, they're less likely to enter educational support orders. Obviously, that's pretty uncommon where a child's going to have significant income or assets. Court will also consider the availability of financial aid from other sources, including grants and loans. That's pretty obvious. The reasonableness of the higher education to be funded, considering the child's academic record and the financial resources available. They're going to look at the child's preparation for, aptitude for, and commitment to higher education and evidence, if any, of the institutional of higher education or private occupational school the child would attend. So that's basically what the court's going to consider in determining whether or not they're going to enter an educational support order, and if so, how much. This is one that's important and is often overseen by parents who are already divorced, where what can sometimes happen is one parent is closer to the child and they kind of make a unilateral decision about where the child's going to go to college without consulting the other parent. And you need to be careful when you do that, because it can prevent you from seeking an educational support order in the future. So the language is that at the appropriate time, both parents shall participate in and agree upon the decision as to which institution of higher education or private occupational school the child will attend. The court may make an order resolving the matter if the parents fail to reach an agreement about where the child will go to school. So again, it's very important that you get ahead of this and talk to your former spouse or current spouse if you're still going through a divorce about where your child is going to go to school. And if the two of you can't reach an agreement on that, you should file a motion with the court to resolve it. The educational support order may include support for any necessary educational expenses, including room, board, dues, tuition, fees, registration, and application costs, but such expenses shall not be more than the amount charged by the University of Connecticut for a full-time in-state student at the time the child for whom educational support is being ordered matriculates, except this limit may be exceeded by agreement of the parents. So basically, the maximum that the court can order with regard to contribution to college expenses is the cost equivalent of 4 years of undergraduate tuition at UConn. Now, that doesn't mean that the child has to go to UConn. Child can go to, a private school that costs $60,000, $80,000 a year, but the maximum the court can order is that cost of UConn undergraduate education. And it's not just tuition, it's room and board, et cetera, as is listed in the statute. But the parents can agree to contribute more. So at the time of divorce, you might enter into an agreement that says the court will retain jurisdiction over post-majority educational support, and we are waiving the UConn maximum, and we agree that the court can enter educational support orders up to a certain threshold, or you might just say there's no maximum that the court can order with regard to post-secondary educational support. Now, this section does not create a right of action by a child for parental support for higher education. So basically, only the parents can bring one another to court to enter orders for post-secondary educational support. If you're a child watching this video, you can't say, oh, my parents are divorced and they don't want me to pay for college, so I'm going to file a lawsuit with the family court. Unfortunately, it doesn't create that right of action for a child. The parents have to bring one another to court. And this statute also doesn't apply to graduate or postgraduate education. It only applies to undergraduate education. So that's the relevant statute. And now I'm going to get into showing you some of the sample language that you'll want in your divorce agreement or custody agreement. And then I'll show you what a motion for post-secondary educational support looks like if you have to bring your spouse to court asking for a college contribution. So first, here is some sample language for post-secondary educational support. And you'll be able to pull these Word documents from our website if you want to copy the language. So the standard language for the court retaining jurisdiction is that the parties agree that it is more likely than not that they would have provided support for the child for higher education if the family had remained intact. The parties request that the court retain jurisdiction over the post-majority support of the child pursuant to the provisions of 46B-56C. So this is often standard because if your kids are younger, you have no idea like where they're going to go to school, how much it's going to cost, whether or not what your financial circumstances are going to be when your children or child are going to school. So it's basically kicking the can down the road and says, okay, we'll when it comes time for our children to go to school, we'll try to figure it out amongst ourselves and we'll try to reach an agreement. But if we can't, the court retains jurisdiction and either parent can bring the other one back to court, asking that the court enter orders with regard to educational support. So that's the court retaining jurisdiction, or the parents may want to waive jurisdiction and not have the court, be able to enter educational support orders down the road. So in that scenario, it would put the parties agree that it is more likely than not that they would not have provided support to the child for higher education if the family had remained intact. the parties freely and voluntarily waive the court retaining jurisdiction over post-secondary educational support. Another option is to have specific orders with regard to who's going to pay for how much of college. So in that scenario, you say the parties freely and voluntarily waive the court retaining jurisdiction over post-secondary educational support. So neither one of the parents can bring the other back to court. But you still want specific contributions. So after scholarships, grants, etc., have been utilized for the child, the party shall be equally responsible for the post-secondary educational costs of the child. Each party's maximum contribution shall be an amount equal to 50% of the cost of 4 years of undergraduate education at the University of Connecticut. And again, this can be higher than, you can waive the UConn cap and have a higher order, or this doesn't have to be 50-50. It can be 75-25, et cetera. And you're usually going to want to do this specific contribution. If the kids are older and you have a little bit more certainty around what it's going to cost, what everybody's financial circumstances are going to be at the time. That's the norm. I mean, you can enter into this type of agreement really at any time. And then some language that I like to generally put in deals with college accounts. So if either party elects to open their own separate college savings account for the child after the date of dissolution and make contributions to that account, those funds shall be credited towards the party who made the contribution in any future court proceedings or order for post-secondary educational support. So let's say you get divorced and you have contributed, $25,000 to a Chet account for your child, whereas your ex-spouse has not contributed any money towards a Chet account. When it comes time for the court to enter orders, if you have that money in a college savings account, you will, and the court says it's a 50-50 split of tuition. With this language, it specifically says that you will get credit. You will get a $25,000 credit based on the funds that you have in a Chet account. So that's just protecting those who contribute to college accounts, particularly when their ex-spouse is not making a similar contribution. Now, ideally, you and your spouse or ex-spouse will try to reach an agreement about who is going to pay for how much of college, and you don't have to go to court to figure it out. But obviously, there are going to be circumstances where you don't agree and you have to go to court. You have to file a motion. So here are some sample motions. First, I'm going to talk about a pendente lite motion. So that's a motion that would have to be filed to resolve college contribution while a divorce is pending. So if you're going through a divorce while your kids are in college or going to be in college, then you have to file a motion pendente lite. So the motion says that pursuant to the statute we just went over, the plaintiff in the above referenced matter hereby moves that the court enter orders compelling the parties to contribute to the child's qualifying post-secondary educational expenses while the divorce is pending. As grounds for such motion, the plaintiff states that the divorce action was commenced on a certain date. The child will be a freshman or sophomore or whatever he or she will be at, and then name the institution and when they'll be starting or when their next semester is if they've already started. And you might put something in that says that the parties mutually agreed that the child would attend so-and-so a school. Again, that's referenced back to that section in the statute that says that the parents have to try to reach an agreement on where the child will go to school. And you agreed that they would contribute towards the cost of tuition. If that's the case, that may not necessarily be the case. You may instead be making the argument that had the divorce not been pending, it's more likely than not that the parents would have contributed to the cost of school. And then you just put, standard language that asking the court to enter orders that the parties contribute to the cost of college. And then on that motion, it's going to be a certificate of service. You don't have to have a marshal serve the person because there's already divorce pending. So that's a pendente lite motion for post-secondary educational support. And then this is a sample post-judgment motion, which is dealing with, divorce is already over or custody case is already over. And, sometime down the line, you need to bring your former spouse back to court because you can't reach an agreement on who's going to pay for how much of college. So this is, it's pretty similar to the motion before, but you're asking the court to compel the parties to contribute to the post-secondary educational expenses. You'll put that the marriage dissolved by way of separation agreement and put the date that your divorce was finalized, list your child or children that you have. And again, what year they're at, what year they're in school and when their next semester will be or when they'll be starting. And put that you mutually agreed that your child would attend so-and-so school. And then you're going to want to cite the provision of the custody agreement or divorce agreement that deals with post-secondary educational support. So presumably there will be some section that will reference back to the court retaining jurisdiction over educational support. And then, you put the relief that you're seeking, which is in order that the parties contribute to the post-secondary educational support of the child or children. And like any post-judgment motion, you need an order for hearing and notice because you have to have your former spouse served by a marshal because it is a post-judgment case. So those are the basics on post-secondary educational support and college contribution in a divorce case or a divorce case that's already over, or a custody case. Doesn't necessarily have to be a divorce case. So as usual, if you have any other questions about this, feel free to give our office a call. We'd be happy to help you out or answer any questions that you have.